Hello, and welcome to the Ministry of Government Relations two-part webinar series on servicing agreements and development levies. This video is part 2 in this webinar series and will cover what development levies are and how they can be used, development levy bylaws including common content and the process for approval, opportunities for appeal related to development levies and servicing agreements, a series of scenarios intended to get you thinking about how development levies or servicing agreements may be used, and best practices when employing either of these tools. The first video in this series detailed the legislative framework governing both servicing agreements and development levies. As a quick refresher before we dive into this webinar, development levies are addressed in sections 169 through 171 of the Planning and Development Act 2007 and are a tool municipalities can use to recover capital costs where there is no subdivision of land. Capital costs are also defined in the Act, and the definition is shown in the blue text box on screen. It's important to remember that not all capital costs are eligible to be charged through a development levy or servicing agreement fee. A development levy or servicing agreement fee can only be charged once to the same development for the same capital cost. However, if a development intensifies or expands, a levy or fee specific to the new portion can be charged. As we go over development levies in this webinar, remember that this is a tool that can be used when there is no subdivision of land involved in a development proposal. There are 4 prerequisites to be able to establish a development levy for a municipality. 1. The use of a levy must be authorized in an official community plan. 2. A municipality must have conducted a future growth study to determine things like population growth rate, areas where growth is expected to occur, and have an idea of what services will be required to accommodate the new population. This is usually undertaken for a 10 to 15-year time horizon. 3. An estimate of what new infrastructure will cost, including what upgrades to existing infrastructure will cost. A municipality has to know approximately what its costs will be in order to charge a fee to recover them. 4. Finally, the municipality must adopt a development levy bylaw. We'll talk more about what may be included in this bylaw in the following slides. Conducting a future growth study and developing an estimate for infrastructure can be challenging and usually require the help of civil engineers and planners to understand infrastructure capacity and need. Once a municipality has a sense of its future infrastructure costs, it can establish a development levy rate based on those costs. Typically, this is done by looking at the amount of land that will be needed for the estimated growth and dividing the costs by the amount of land to get a per hectare rate. This rate can also be calculated on a per lot charge. The rate can be a flat rate charged to all development or varied based on the land use type. Some land uses may have a larger impact on services than others. For example, an apartment consumes more water and generates more waste than a single detached dwelling. A municipality is not obligated to charge a levy for the full costs of future upgrades. Some municipalities have chosen to only collect levies for 2/3 of the capital costs in recognition of the benefits that some developments can bring to a community. It's at Council's discretion how much of a levy to charge once they have the cost estimate. Since development levies are charged when there is no subdivision of land, the Act specifies that they may be collected with a development permit. The timing for the collection of levies can also be negotiated with the landowner through a development levy agreement. It's important for a municipality to review and update the estimated costs and rates in the development levy bylaw regularly. This ensures that increases in infrastructure costs are reflected in the development levy rate being collected. Now that we've established how a development levy can be charged, we'll go through some of the common items that may be included in a development levy bylaw. Many of these provisions can also be found in the Development Levy Bylaw model on saskatchewan.ca. A bylaw will typically start with an interpretation section outlining the definitions that will be used. In some cases, these definitions may be taken from the Planning and Development Act 2007. Council may also delegate the administration and enforcement of the bylaw to the development officer, such as requiring payment of development levies. Only municipalities designated as an approving authority can authorize the development officer to enter into a development levy agreement on behalf of council. A development levy bylaw should clearly state the development levy rate. In some cases, the rate is included in the main body of the bylaw. In this model bylaw, details on the development levy rate are included in Schedule A, which we will go over in the following slide. In the interest of transparency, it is recommended that the studies used to determine capital costs also be attached as a schedule to the bylaw. The bylaw should clearly state the development levy rate. In the sample bylaw, different rates would be established for various types of land uses, which vary as a percentage of the full capital cost of development on a per acre basis. For example, under this bylaw, the municipality may establish different development levy rates for residential single-family developments and residential multifamily developments based on a percentage of the full capital costs. Similar to servicing agreement fees discussed in the previous webinar, the Act is specific in the types of services and infrastructure that may be included in a development levy. Eligible items include the capital costs of providing, altering, expanding, or upgrading sewage, water, or drainage works, roadways, and related infrastructure, parks, and recreation. Maintenance and operating costs are not eligible under the definition of capital costs in the Act. Eligible costs incurred in neighboring municipalities can also be charged back to an applicant. The reason this is allowed is to recognize that growth in one community can affect the services of neighboring communities as well. It's important for the municipality to reasonably demonstrate the link between the development and an eligible capital cost under the Act. Any costs need to directly or indirectly service the development. Ask this question: how does this development contribute to the municipality's capital costs? If the costs do not directly or indirectly service the development, the applicant could appeal the fee to the Saskatchewan Municipal Board. If a development levy bylaw is being adopted, amended, or repealed, public notice must be given following the minimum requirements of Part 10 of the Act. The minimum standard includes a newspaper advertisement circulated once each week for 2 consecutive weeks. We recommend that other methods be used to give public notice in addition to the newspaper to try and reach as many residents as possible. This may include posting the advertisement on the municipal website or social media pages. The Act requires that the first public notice be posted in the newspaper at least 15 days prior to the public hearing. The calendar on this slide shows the minimum time frame for meeting this requirement. Once Council approves the bylaw, it must be submitted to the Community Planning Branch. All bylaws submitted to the branch are reviewed for compliance with the Planning and Development Act and the Statements of Provincial Interest Regulations. The submission to Community Planning must include 2 certified true copies of the bylaw, a statutory declaration completed by the administrator, copies of the public notice, a copy of the public hearing minutes, including details of all representations made at the public hearing, and copies of all written submissions made respecting the bylaw. A development levy bylaw has no effect until it is approved by the minister. Approving authorities do not require approval from the minister for the adoption, amendment, or repeal of a development levy bylaw. It's important for all development levies or servicing agreements to be justifiable and follow what is specifically authorized under the Act. Proponents are granted the right to appeal many aspects of the development levy or servicing agreements to the Saskatchewan Municipal Board. The proponent may appeal on the basis of 1. The capital work or project for which the development levy or fee is to be collected does not directly or indirectly serve the proposed development. For example, the cost of a new sewage lift station to service a different area than where the development is proposed. 2. The development levy is not for capital costs. The cost incurred is not an eligible item in the Act. For example, library costs are not authorized to be included in either tool. 3. The calculation of the development levy is incorrect. The capital costs may be eligible, but perhaps the calculation of what should be attributable to this particular development is not reasonable. 4. The levy or its equivalent amount has already been paid. The Act only permits a levy or fee to be charged once to a development unless there is a substantial change in the impact to services. 5. Failure to enter into an agreement within the specified time. During the review of a subdivision application, the municipality and developer have 90 days to negotiate the terms of a servicing agreement. This time frame may be extended if mutually agreed to. After this time, the developer may appeal to the Saskatchewan Municipal Board. 6. Terms and conditions of the agreement, such as if the developer believes standards or fees imposed in the agreement are unreasonable or unjustifiable. In the following slides, we're going to go through 5 scenarios to better understand eligible costs and whether a development levy or servicing agreement is the best tool to use. For each scenario, we will go over whether the municipal cost is an eligible item that can be included in a charge to the development proponent. This will either be a yes or no answer. And whether a development levy or servicing agreement tool is more appropriate. You are encouraged to pause the video at the start of each scenario and think about how you would answer both questions. Scenario 1. The City of Sheep has received a subdivision application for 15 new residential lots. The new lots will receive pipe water and sewer services. The city has been experiencing a lot of growth recently, and its water treatment plant will need upgrading soon. The city would like to charge the applicant part of the cost of upgrading the water treatment plant. Is this an eligible cost? Yes. Capital costs related to the expansion of water services are an eligible item. What tool should the city use? As this is related to a subdivision, a servicing agreement would be used. Scenario 2. The town of Mountain has received a development permit application to redevelop a house into a fourplex. With the increased number of units, the town would like to charge the applicant part of the cost to upgrade the water reservoir. Is this an eligible cost? Similar to example 1, capital costs related to the expansion of water services is an eligible item. What tool should the town use? As this is not related to a subdivision, a development levy would need to be used. Scenario 3. The rural municipality of Luna, number 16, has received a subdivision application to split an existing house from the rest of the quarter section. The property is serviced with an on-site water well and mound sewage system. The RM would like to charge the applicant their standard off-site fee, which includes charges for water treatment and lagoon upgrades. Is this an eligible cost? As the property is not receiving the services that the fee is based on, this would not be an eligible item. Scenario 4. The resort village of Blizzard has received a subdivision application for 20 new residential lots near the lakeshore. The resort village uses the adjacent rural municipality's lagoon for sewage treatment. The RM has indicated that the lagoon will need to be expanded to accommodate the new residential sites. The RM has asked the resort village to charge the applicant part of their costs to expand the lagoon. Is this an eligible cost? Yes, this is an eligible cost. In this case, the resort village and RM would need to enter into an agreement stating that the RM would be responsible for the disposal of sewage from this subdivision. 2. What tool should be used? As this is related to a subdivision, a servicing agreement would need to be used. Scenario 5. The rural municipality of Many Deer, number 416, has received a development permit application for a new gas station and service center on a vacant lot. The RM thinks that the increased traffic on the roadway will result in them needing to grade it more often. The RM's grader is getting old, and they'd like to charge the applicant part of the cost of a new one. Is this an eligible item? No. Graders are considered maintenance costs in the Act. Only capital costs, as defined, can be charged back. While new equipment may be traditionally considered a capital expense, the cost is considered an operating and maintenance expense. It's not included in the Act's definition of a capital cost. On this slide are several suggestions for making the process of collecting levies and fees as smooth as possible. 1. Negotiate the standards for new infrastructure in advance and attach the agreed upon standards to the agreement before it's signed. If a municipality has adopted design standards, those can be attached to the agreement. Otherwise, engineered drawings approved by the municipality showing the details of what will be installed can be attached. 2. All levies and fees should be easily traced back to an eligible capital cost. A municipality should be able to reasonably demonstrate how a new development will impact infrastructure costs and capacity. By having this figured out ahead of time, it prevents unnecessary appeals to the Saskatchewan Municipal Board. 3. The Act allows for development levy agreements and servicing agreements to be registered on the affected property titles. In cases where there are significant amounts outstanding or key infrastructure that still needs to be installed, registering the agreement allows any potential purchasers to be aware of their requirements. If the agreement isn't registered on the title right away, someone else may purchase the property and be unaware that important conditions need to be fulfilled before it can be developed. Number 4. The municipality should always advise applicants of their right of appeal. This improves transparency and good governance and allows applicants to be aware of their ability to challenge aspects of development charges. Number 5. Determining reasonable capital costs can be challenging and often requires retaining a professional to help establish costs. Costs associated with retaining a professional to do an infrastructure assessment can be charged back through a fee or levy. To wrap up this webinar series, we will reflect on some key lessons. Development levies and servicing agreements are an important component of responsible asset management and ensures new growth does not cause significant municipal costs outside of regular maintenance. When using a cost recovery tool like development levies and servicing agreements, align the terms and conditions of the agreements with the Act as closely as possible. This can mean quoting the Act for specific elements, including definitions that align with Part 8. Any levies or fees being charged should be justifiable and relate to the eligible municipal costs. A municipality should be able to reasonably demonstrate how the development being proposed contributes to the capital costs. It can save a lot of time and negotiating to have municipal infrastructure standards adopted in advance of development occurring. Similar to adopting municipal standards ahead of time, understanding the impacts of new development on existing services can save time when negotiating with applicants. Asset management can go a long way to allowing a municipality to recover its costs. This concludes the webinar series on servicing agreements and development levies. In addition to these webinars, there are a variety of resources available on saskatchewan.ca that can help municipalities use these tools appropriately. If you have any questions about the content of this webinar, please contact the Community Planning Branch using the information shown on screen. Thanks for watching.